So I've I've filled in two Subpoena forms, which it's kind of like they're sort of like summons and subpoena in one. It's kind of like the forms for the High Court for subpoena is sort of like you can even either compel a person or just compel the information. So it's sort of like a multi-purpose form, really. You can kind of summon a person or just information or data. Obviously, if you don't need the person to appear, you just require them to provide the information. So basically, that is the subpoena form. It's kind of like a kind of multifunctional kind of form, from what I can gather. So I submitted it to the High Court Judicial Conduct Office because the office is the office is part of the High Court, right? So when you've got a case against a judge, it's almost like when you're bringing a case against a judge, it's a proper case, and regardless of whether it's you win or not, it's still an investigation, really. It's your investigation, just like a criminal investigation in the normal courts, but it's in the High Court, and that's why the Judicial Investigation Office is in the High Court. Also, it has higher jurisdiction over all of the other courts, except the Supreme Court, but then the Lord Chief Justice is in charge of the Investigations Office. And I've also noted from the Constitutional Reform Act, which is the one which Gordon Brown government brought in when they invented the Online Petitions Committee, and also they repealed those Appeal Act Jurisdiction Acts for Parliament. So there's still jurisdiction of the Privy Council. Have still got kind of like a court and a jurisdiction still within Parliament. So effectively you can petition the King under a certain jurisdiction rather than either of the Houses of Parliament, really. According to the new Constitutional Reform Act, it still has a jurisdiction. And also, the Lord Chief Justice and Chancellor and so forth they've got they can lay matters and representations to the Parliament, to the House of Commons. So there's a communication. The Judicial Conduct Office that is headed by the Lord Chief Justice, right, and the High Court, can lay documents, representations and matters to the Parliament, which means that will encompass the House of Commons Petition Committee. And that also means that they've actually got jurisdiction over the Petitions Committee. Now, the Petitions Committee have got a jurisdiction in the House of Commons, even though it is limited, because they are a form of tribunal for inquiry. Well, in order to operate, they've got powers over that under that 145A standing orders of the House of Commons, which is they have got limited court powers, which is kind of like for basically summoning and compelling evidence. It's the House of Commons Petitions Committee is like these committees of Parliament have got jurisdiction. They're like small mini tribunal inquiry, and they can have subcommittees as well. And obviously, why would you get a public inquiry is if it's important or serious matter, like Hillsborough. I mean, obviously, if it's only a small matter, it can be dealt with by the House of Commons committees, if not a court. But that's why don't courts deal with, Hillsborough public inquiry? Well, because they're busy doing work, and there are limitations for sizes in casework, and that's why they set up these inquiries, because it's going to be focusing on one matter for quite a substantial amount of time. And the thing with the Inquiries Act 2005, like I said before, it gives them investigative powers and so forth to compel evidence and summon people. And the thing is, if it needs to, if there needs to be any court action, it has powers to refer the matters to the courts, like to the Supreme Court or to the High Court, even, which is the Royal Courts of Justice anyway. So it's kind of circular in motion, really. If you think about the House of Commons, and if you want a public inquiry and get one, and then the public inquiry is kind of like a court set up for just to investigate something on an important or national matter like Hillsborough or something, and then if there are any legal matters to make orders for, either criminal or civil, in regards to the inquiry, then it can refer them to the High Court. So you come in kind of back circular, and then obviously again the High Court can lay matters and report into Parliament, to the Commons, right? So, the question is, what the Petitions Committee at Parliament always says: you can't petition about criminal matters or complaints about ministers or whatever. It's dealt with by Ombudsman or by Privileges Committee or so forth and so forth. But, the Lord Advocate is a member of the Privy Council because he's got the title Right Honourable. Right Honourable people are members of the Privy Council, even though they might not be on the judicial part of the Privy Council. In the Privy Council, there is like people who have got, judicial powers. But the people in House of Commons have got certain judicial powers, limited judicial powers, in order for the committee to operate and so forth. Now, with that Subpoena, the thing is, so you got Magistrates Court, usually Crown Court is where people appeal, or if it's more serious, right? But then you've got the High Court, right? But then you've got the Supreme Court. Now, the thing is that when I'm complaining to the Judicial Conduct Investigations Office, you're opening you are the plaintiff and you're bringing a case, right? So, but it is in the High Court. That Office of Investigation is a higher Office of Investigation. So you have got a case within the High Court, but it's just managed by a special unit within there, right? Now, I have filled in the proper High Court subpoena forms, right? Which if you've got a case within the High Court jurisdiction, then those forms are for when if you've got a case, an investigation of any. It can be an investigation, or it can be civil or criminal in the High Court. So I filled them in, right, because I want certain information in regards to my case, right, in my complaint, which I think's what I can decide. The thing is, right, at the end of the day, right, in that on that claim website and on those claim web forms, there's a button for me to write statements and add evidence. But it's for me to add evidence. What I choose to add it's my button. I can upload. I select things and submit them. Now, if they don't think they're relevant and want to ignore them or disregard them, that's fair enough, but I've got the right to submit it. So, like, even though the Judicial Conduct of Investigations, they are the main investigator, I'm still a plaintiff, right? You can't have a case without material. Someone brings a case. So, because I've got the right to upload and add files, I've got the right to request information for that. Like, I've put an application in for evidence from the BBC. I know that it's a case against a judge, and the conduct of a judge. But I want that evidence from the BBC, because that is the evidence, that is the first evidence, that is the main and first evidence which bases all of the whole thing. If it wasn't for that programme, none of the events would, or my campaign, or my casework to Parliament, or anything would have existed without that BBC broadcast. And it's important because it proves that a practicing barrister, lawyer, Nick Freeman of Manchester, quite a renowned, famous, well-known barrister and solicitor, he made statements on air to the public about, illegal road signage and enforcement and so forth, that the actual the issue exists, a problem exists with it, and required investigation. And without that, without those statements, I wouldn't have been called to investigate the matter. I wouldn't be even know about an issue, and that's what led to the facts and circumstances of my case and the charges against me. And I know that my particular complaint with the High Court are going to say that they only want they're only interested in things to do with DJ Watson's conduct and behaviour, but DJ Watson's conduct and behaviour relies upon the existence of my case and my presence there, and his conduct and responses to my to me and my material, and his actions, words, and so forth, and the legitimacy of the proceedings. I want that material from the BBC because it's important. It's important for the existence of the whole thing. Those statements on air are the basis for the House of Commons case, of which I'm claiming. My claim against Watson is that he's injunctioned against proceedings from he's out of jurisdiction. He's out of jurisdiction. That is a complaint. The complaint is that Watson is out of jurisdiction, and he also obstructed my investigation. By removing my he punished me and removed my ability to proceed. He says, and if he's obstructed the investigation. He's derailed and obstructed. In fact, he has terminated my investigation. He's terminated my investigation, really, because I don't have the ability to investigate it anymore without my driving licence. And my case was already existing to a higher court, So, and we've got evidence now that magistrates' courts in local jurisdictions are not. It's meant to be. It was supposed to be the King's Bench. And also, when you're petitioning the King, you're meant to actually automatically get a case like the Star Chamber. And at the end of the day, even though they've got the Constitutional Reform Act, they've still got Privy Council and a court there anyway. And the House of Commons is a small tribunal, and it's meant to refer matters to the High Court anyway. So the Petitions Committee, I can't see in that Constitutional Reform Act that the Petitions Committee are lying, because firstly they say they're not working on any law, when we know that you work on the law of the right to petition. we know you work on, they don't even know what act they're using when they're publishing on their own website, which, that goes to show something. And, a minister can initiate a public inquiry, which is what I would petition him for, based on the weight of the evidence or evidence of public concern or support. I only collected 20 signatures, but my petition really is on the strength of the facts that I collected, the facts and the material evidence, the body of my case, which is contained on my website and on my YouTube channel, and YouTube have taken it away from me unlawfully, which I've also got a subpoena as well to restore access to that data through my own login, which is through my email address, which is how I access that data, because YouTube have unlawfully seized evidence in a criminal investigation in House of Commons casework, so now the judicial conduct investigations is in the High Court, and they are doing the investigation work, but I'm uploading material I think is relevant or that I want to submit, and they can get a judge to authorise things like that when they're doing it. So there's no reason why I can't request the information or data to get signed off. Now, another thing is this, and I've been talking for like 16 minutes now. So I'm actually also going to upload, there's some famous casework with these guy called Bastwick, and I think the other guy is I think he's called Burton. And it's quite a famous case that is well researched. It's a famous study case for students about these ecclesiastical cases to do with like the church. They were writing books and publishing stuff which the government thought was illegal or unlawful, and these people got prosecuted by this court of commission, which was kind of like the religious court. But you see, these figures, these people, when they got these hundreds courts, they also had church courts. I think they had church courts in Scotland. They've got church courts in Scotland, and I think they got church courts in England, because obviously these church courts can make orders, and judges like the priests have got a certain judicial power. So, but this Bestwick or Bastwick, they're already in these kind of like lower, church circles and so forth, but they're getting prosecuted. This is when you've got conflict of religious interest, which they're actually getting called to court and prosecuted. I've just done a video on it. I don't really want to talk about it again, but they ended up getting put in prison basically by this court of commission. But they had cases in the Star Chamber as well. It's looking like they did some sort of petition of appeal in their cases, but they eventually get released by the Long Parliament, this John Pym's Parliament. The wives petition for their release to the Commons, which you can do that. It's actually to the Commons. I don't know how they motioned it. I don't know by what methods they actioned it, but you can have it. You can do it. I don't care if they've changed jurisdictions or not in that Constitutional Reform Act, because the current Parliament Petitions Committee are lying about many things. They're lying about what you can petition about. They've got these standards which they keep going on about, which don't exist in law. They don't exist by standing order. They don't exist in law. There is no legal basis whatsoever at all for their standards. And they're pushing their own political opinions and views and censoring legitimate casework of the public under the premise of it's not up to their standards, which is perverting the course of justice, basically, as far as I'm concerned. Now, that House of Commons Petitions Committee, it claiming that you can't petition about criminal matters, which is not true, because I've got a listed petition over investigation into illegal road signage, which can have an inquiry. So the House of Commons and any minister in the Commons can initiate a public inquiry. And then that public inquiry can refer matters to the High Court, any criminal or civil matters. Now, what the House of Commons are trying to make out is they're trying to make out that they can't refer any matter or any petition or any issue to the courts, right? That is a lie. Because it would be like saying that you can't report something to the police. Any citizen can report something to the police, right? Anyone in the country can report something to the police. In fact, Andrew Bridge, an MP, this big post office scandal, there's a big post office issue out at the moment to do with, the woman who's in charge of the post office getting an OBE stripped, people are calling for now. And, Lib Dem leader is involved in it, and he was part of oversight for the post office and so forth, right? So there you've got investigative powers and to direct things in committees for the post office. So that's, for a start, directing proceedings in criminal cases. Andrew Bridge, an MP, his constituents, he was one of the first people to raise the alarm about the postmasters and the post office, right? And that actually did result in prosecutions. So how can you say that a minister cannot refer something or initiate investigation or proceedings that doesn't necessarily have to be a public inquiry itself? Now, the House of Commons Petitions Committee are saying that you can petition to them about criminal matters or whatever, or wrongdoings, which is false. Any minister, Andrew Bridgen's assisted and helped with matters. So that means that Martin Day MP, Scott Benton, anyone on that committee can do that, right? Or else that Andrew Bridgen wouldn't have been able to act in any way at all for the Postmasters issue. Now, the Constitutional Reform Act says that, the Lord Chief Justice, which would therefore automatically qualify the Judicial Conduct Investigations Office, because they're in charge of it, right, to lay any matters and representations or anything to the House of Commons, which includes the Petitions Committee if it's House of Commons, right? So, but then again, you've still also got this, the jurisdiction of the King or the Queen with the Privy Council, and their jurisdiction is retained in that Constitutional Reform Act of 2005. Now, with my issue, right, I already had a case, an investigation with the House of Commons Petition Committee, but I'd also petitioned Her Majesty the Queen about it personally in letters. And she was going on about referring the matter to her ministers, right? Which where are the ministers? In Parliament, right? So, but they do have, there is a jurisdiction there with the monarch in the Privy Council. Now, and when, if you petition the case there or brought the case, it seems like they've kind of there's a long-established right to have a matter brought to the jurisdiction of that Privy Council, and it's established before Parliament, and before Parliament becomes semi-permanent and short Parliament, and then long Parliament, and then every 3 years, and then a permanent Parliament. But the 1688 Bill of Rights actually consolidates that right to do it. But even with the casework to Parliament, you're bringing a case very similar to under the jurisdiction of the public inquiry anyway, but it's like a small version with limited powers, but it's still powers and it's still casework. and notice that the inquiries are, any legal matters to do with the inquiries are referred to the High Court. It's not actually to the Magistrates Court or Crown Court, it's to the High Court, so like I'm 25 minutes in now,